G'day, Kim, how are you?
We've jumped right into
I know, there's no green room
no
today.
breathing space at all. This will be interesting, Andrew. We're on the last stretch and we're both thoroughly
Oh
exhausted.
no, and I have just landed. I've
I
only
know.
literally got off a plane, so
With our Sydney Christmas party.
yeah, I'm a bit damaged by
Oh.
that.
Thought you weren't drinking anymore.
Oh no, it was the two dirty margaritas that
Oh.
got me. And then, can I just say to Elena who did that, thank you for the drink, but I'm not feeling thankful today. Got an interesting day today because we're going to talk about this major theme heading towards Christmas. I know it's sort of a traditional discussion, but sadly it's a pretty important discussion,
Yeah.
isn't it? Because we're starting to already see the behaviours come through across our desks.
Yeah.
I think I was joking with someone yesterday. It's like someone put bloody idiot tablets on a shelf at Chemmart, and people have just been swallowing them by the handful, isn't it? But we always see odd and quite dangerous behaviour heading into Christmas. And then, of course, we turn up on January and are presented by 5 sexual harassment complaints and a bullying complaint. And I'm tired of it, I think. And now with the changes in the law, it's also frustrating that I don't think organisations quite understand their level of liability now compared to last year as well.
Yeah.
So we'll talk more about it, but it's interesting, the Rio and BHP class actions for sexual harassment. You read that this morning?
Oh, that was horrific. I just can't believe that people still behave that way. I've got to be honest.
Yeah, well, of course, unproven as yet as allegations, but when you read them, I sent the article through. I was sitting on the plane and said to Kim, read this. And then I got the response back. That's just shocking. I think we as Australians really have to face up to the fact that there is an entrenched, very muscular culture, particularly in the trade area, that just has to be addressed. And as women come into working in trade and manufacturing other areas, which they must and which is great, there is a significant change in culture and behaviour that has to occur. But look, we'll deal with that later. Why don't we jump onto our first case, which is Sabak's case. Pretty interesting case in some ways, this case, because this was a guy who was an Israeli-born engineer who did some 3D modelling for some cylinders. He came to work for a business. He had flexible work. He went back to Israel for over 100 days, came back. And when he came back, they needed everybody to really hunker down and get on and design and build these things.
And keeping in mind, it was his technique that they were rolling out, and they were really relying on him to teach the other staff.
Yeah. One of the managers said, well, let's create a war room and go in there and work. And he took offence because he'd been in Israel. He'd lost a family member during the war. He took offence at what was said with the definition of it. But then he resisted repeated lawful and reasonable directions to go and participate.
And teach the team.
I think this case is interesting on two fronts, Kim. This is the second week in a row where we've seen people use the word safe. The first one was employers are increasingly saying, I don't feel this environment is safe. So the language of psychological hazards is out there and being used as a lever. But we're also starting to see HR professionals and other people sometimes go and look at Regulation 107 and go, an imminent risk to the health and safety of someone, and actually quote that in a termination letter. Now, this gentleman was aggressive and direct. Nobody ever suggested he was creating an imminent risk of threat to somebody. So that went in the summary termination letter, and that was given really short shrift. It was said aggressive, unhelpful behaviour, a lot of things, but certainly not creating an imminent risk. So that's the end of the serious misconduct argument, except for the lawful and reasonable direction. And the issue here really is this is something that deserved counselling. And what I do love about our Fair Work Commission, and can I just say it's appointed from every part of our political landscape, is that after a period of time, there's a level of common sense that descends on the Commission, where they go, he didn't do what you told him to do, but then you did nothing about it. You just sacked him. And I understand your frustration because he wouldn't do what you said, but he's got to understand the consequence. So he didn't seek reinstatement. He got $20,000 and that's life. But I guess coming back to employers, don't point a gun at someone if it's not loaded. So the imminent threat to safety. Remember, be careful about the use of safety. This is a very simple issue of giving someone a direction and refusing to. When someone does that, you stop everything and say, look, I'm going to give you 10 minutes to have a think about that. And then we need to have a conversation because there are consequences if you don't do this. And you say, look, I'm going to give you the direction again, but understand if you refuse to do this, given that your role is so critical in this, then there will be serious consequences for your employment. Didn't happen that way.
No.
Okay, so I thought a really interesting case for the two reasons. One, the reaching for the gun into the regulation rather than dealing with the facts.
Yeah.
Remember, facts are king in all unfair dismissal.
Yeah.
But secondly, the failure then to respond in an appropriate manner and give this guy a get out of jail free card. And goodness gracious, he's the guy who held the key to their production. So it was such an odd thing to do.
Yeah.
Why don't we head off to our next case?
Okay.
Yeah. And I'm just trying to think.
Well, I was impacted by that on the weekend because my supermarket was empty.
So was mine. And I want to talk to you about some strategy here, because this was a really odd choice that was made by the solicitors who are acting, and I'll explain why it was an odd choice. What happened here is the union picketed warehouses that supplied goods to Woolworths. Can I just say this has a massive impact in food processors who provided Woolworths, who lost that production, then had to lost it again, and it just kept happening. So outside of Woolworths, forget about Woolworths, very sorry Woolworths, but the people who supplied Woolworths have suffered terrible losses which don't form part of this. But what happened is the union formed a picket. Why did it do this? Well, what happened is Woolworths imposed this new testing method of directing people to do things in specific times, which was oppressive, intrusive and unreasonable. And the union were furious about it and said, look, it is hurting people, it is harming people, it's an automated method of measuring someone's performance, it's not acceptable. And there were some other issues as well. So the union said, no, we're going to picket you, we're going to hit you just before Christmas. So they took lawful industrial action, but the picket prevented people from coming in and out and prevented vehicles from coming in and out. So we got the empty store that you're talking about. It was in 3 states that this occurred. So what's the action you could take? The traditional action, and probably somebody like me would have gone, well, we'll take it in the Supreme Court of Victoria to start with and we'll roll it out. We'll get our orders because it's illegal. We'll test it. We'll get videos and people trying to get through the picket. And at that stage, we'll get an injunction, and a breach of an injunction is a contempt and you can jail people for it. Okay? Yeah. Why do you do that? Well, yes, it's in one jurisdiction first, but it sets the lesson hard. And it puts union organisers on notice they can go to jail and there's significant penalties that go with it. It's the right strategy. Yeah. Or you can do this second strategy, which gets every state at the same time, and you base it on good faith bargaining, which is absolute nonsense, and you try and get an order which you can't enforce, okay? Unless you take it up to the federal court, seek to enforce it, and then when the federal court makes an order, then you've got a contempt. So this was really Woolworths trying to bring people together to try and get a deal, and they lost hands down because they rolled on the deal. They got their order, which says it's unlawful, and everyone went, who cares? You're still allowed to do your lawful industrial action, so they'd still be allowed to picket, but they'd let people through. But you know what would happen is people would be reluctant to do it. Yeah. So they rolled on everything. And they rolled on everything because you could argue their legal strategy didn't have any bullets in the gun. Okay? But they're probably going to roll anyway. Does that make sense? So this was a way of trying to get a universal order across the states. Good strategy in that respect. My view is if you want to take on someone like Tim, who's the head of that union, who's a really clever, good unionist and doesn't pull industrial disputes unless there's a very genuine need to do it. And this method of automating the measurement of people's labour in a warehouse is pretty awful. They pulled the fight with the wrong person. Yeah. And they lost in a big time. And I think for Woolworths, they can say they lost $50 million. The people who are the processors and the suppliers to them have lost much, much more and had much less chance to recoup that loss. This is a terrible mistake and shows the problem when we have two major retailers working in the space, doesn't it? Anyway, look, interesting, great legal strategy, good challenge to have a kick around. The barrister's a great barrister who was acting for them, so there's clearly an aim of what they were doing. But I just thought I'd let you know what is the old-fashioned IR strategy and what you would have done versus what was done here, and you'd be the judge of what you reckon is the best. We might move on. I think this is now to the redundancy case, isn't it? Yeah, again, I don't think there's much interest.
No, it's just a jurisdictional argument in the Fair Work Commission after someone was made redundant. He didn't believe he could be because he was working under a flexible working arrangement. In Japan. Working overseas. Yeah. And the Commission said, well, you know, this operational issues arise for businesses all the time. Doesn't matter if you're on workers' comp, personal leave, carers leave, whatever the case might be, you're not immune.
That's right. So I think what Kim and I put this on for one, what we put this on is just to say to people, when you go to do a general redundancy, it doesn't matter what people are doing. If they're part of the game, they're part of the game and they can't get out. Okay, so I put this case on, and it is a case which is about a director shareholder and a restraint. Okay, there's this whole series of actions that sit in different parts of the world, but the restraint argument that sits in the shareholder agreement and the employment contract sits in New South Wales.
Shareholder agreement is in the UK.
Sorry, shareholder
and the employment agreement is New South Wales, and that was the issue.
Yeah. So sorry, I got that wrong. So what Harman wanted is to be dealt with in New South Wales. Now, common law courts throughout the world, it's called conflict of laws, will hold the court hearing where there are multiple jurisdictions in the court of greatest convenience. So where are all the witnesses? They're here. What's the major issue that's being agitated? It's in relation to his employment and shareholders, so they can apply both types of law in the one place. They can sit there and be addressed on the English law in Australian court and the New South Wales court. For Harman, it's really important because in New South Wales, there is particular legislation dealing with the restraints in relation to employment, and you'd want to be in that jurisdiction having that argument here. So a great win, but I just want people to realise it's not uncommon to have your employment contract governed by the law of Victoria, for instance, but you might be employed by a multinational and therefore you're a shareholder and your shareholder agreement might sit in some Arab state. All those things can happen, but the bottom line is where it is heard is where it's most convenient to be heard, and the different laws will apply, and judges are used to it. It's not uncommon. So that's more for me as a lawyer. I like it, but I just wanted to show you, don't think because you're in two different jurisdictions because of documents, you have to go and fight in two different places. Have a chat to your lawyers and work out where the best place to be is. Why don't we jump on to our next case? We've got a lot today, and I think this is a case that I wanted to raise because there are a number of our clients who are in construction business, doing renovations, large gardening, any business that goes to a domestic premises to undertake work, like plumbers and the like, have to understand when they leave things undone, the level of risk. And this was, they removed the balustrade from a balcony for work that was being underdone by a gardening business. And someone fell and injured themselves.
Well, just for a bit more context, they removed the balcony. Shut down over Christmas, and then the friend of the homeowner came and fell off the balcony and died. So they've charged the company who removed the balustrade, obviously.
So
which is interesting because normally we see prosecutions like this relating to injuries to employees of the company.
That's right.
To third parties.
So this is a Section 23 in Victoria, and a very similar provision that exists elsewhere of damage to a third party. But I want people to understand, if you're carrying out work at another premises, whether it's at someone's home or whether it's another commercial premises, wherever it is, the risk you leave behind when you leave is your risk. So interesting case. It'll be a successful charge, I have no doubt, and we'll never see any facts agitated on this other than a pleading guilty. But it's a classic example of third-party risk in the behaviour that you have. All right. Funny case. This is a person who really felt he was being treated badly. He had a family emergency, didn't feel that he was treated well, felt that he was treated badly in everything, couldn't work the times he wanted to work, actually thought he could work different times himself by setting him up.
Got a bit offended when he was told that he wasn't working quickly enough and that he was a bit lazy. I think there's some truth to that somehow in your case.
Not that we're going to get ourselves into defamation law, but you'll be surprised to learn that the Commission, this stop bullying order, didn't make a stop bullying order, but said, look, there's some mistakes that have been made because people were busy, but essentially this is all reasonable management. You're asked to work harder and you're not working hard enough. Seemed fair to me. You wanted to work at a different time. That's not the business hours. Bad luck. Again, I want to come back. Fair Work Commissions has some unreliability on technical issues, but on day-to-day stuff that just runs through, there is this vein of fairness that sits there. This is somebody who's become highly offended and lost track of reality in the process, and the Commission in its own gentle way just pushed the ball back along the track and said, "It ain't bullying, mate."
It's silly. He's left himself nowhere to go. He's ceased work claiming a psychological injury, and he's just really backed himself into
the corner. Yeah, he has, and there's nowhere much to go after that, I'm afraid. So Anyway, that's a good decision. As Kim and I have told you in the past, in any one year, there's probably 1,000 stop bullying applications, which when you look at the population of Australia is almost zero. And there's a reason for it, and that is mostly people intervene before an order has been made. But there's only 5 or 6 successful applications a year because bullying is actually a very high test. It's not a low test, it's a high test. And if you're acting reasonably in the process of managing someone, you always have the defence of reasonable management action. So we're just putting it out there, showing you it's happening. Now I think we go on and we're going to have a look at this contractor case. Okay. So TJN was the principal contractor.
Oh, yes.
And beneath it, it had, I can't remember, it's Carbon, somebody who's the subcontractor. Yeah. And there was an apprentice and a junior employee of Carbon. And Carbon hadn't done any risk management process, and as a result of there being hot tool nearby, the adhesive blew up and caused them terrible burns.
Yeah, that's correct.
Yeah. And I guess I'm so sick of reading rubbish about principal contractors not being liable. Now, there is no doubt that Carbon had particular skills to undertake the work that TJN didn't have.
Yeah.
But TJN had the obligation to be satisfied these people were doing risk assessments and have appropriate first aid, but that was a small issue. So once again, the principal contractor is liable because they fail to comply with their lawful duties under the legislation in being satisfied that the mechanisms for having a safe environment are being followed. So for all the people out there who keep talking in this bullshit that principal contractors are not liable for work they don't have the knowledge and control of, can you read this case?
Yeah.
It's a great decision. It's absolutely right in law, and it reminds us all of that very simple process. A principal contractor has responsibility for the safety on its site. If somebody working under it has a specialised skill, their obligation is to be satisfied that that person is carrying out an appropriately skilled risk assessment to prevent risk to themselves and to everybody else, not just to themselves, but to everybody else. And for some reason, there is this nonsense that's propagated throughout, sometimes by lawyers, that principal contractors aren't liable. It is just crap. Can we get over it? Because I'm sick of it, and I'm sick of reading about it. It's ill-informed, and it's designed to sell a particular concept, which means when you have a principal contractor on site, you don't have to do anything. Well, goodbye. I think we're getting pretty close now, aren't we?
I think that's our main topic.
I think we're on to our main topic, aren't we?
Yes.
We are. Whether we like it or not, we're on to our main topic. This is me who put this on, and I guess for 35 years I've been the partner or principal who's been in charge in dealing with the wash-up of Christmas parties, dealing with all misconduct in businesses, and I'm pretty tired of it.
It's kept you busy.
It's kept me busy, not billable, unfortunately. And it kept me busy for a couple of really obvious things. And this is even just internally in the business I've been in, and that is, it is not hard to stop people bullying and sexually harassing people. I just want to be clear, it's not hard. One, there has to be real consequences when someone crosses that line, and you've got to act on it. But more importantly, you've got to build a culture where it doesn't happen. Now, it's not helped by our courts, can I say? Because our courts are built upon legislation, which is beneficial legislation, which means if someone sacks me for misconduct, the Fair Work Act is designed to protect me. It's a beneficial piece of legislation. But if the person who I harmed gets hurt, it's beneficial legislation and discrimination law. So I may not get sacked, but the person will definitely win a sexual discrimination claim. So it's weird, isn't it? And workers' compensation is beneficial, so the person who is harmed will also win a workers' compensation claim. But do you see where the beneficial part of it falls means that at times the perpetrator may get away with it, but the injured person will have cause of action.
Yeah.
That's really complex, and what it misses is that safety law sits under it all and says, when you're at work, you must be safe. And the employer will be liable. And on top of that, we've now got positive duties throughout Australia, except for Victoria, in relation to safety, to eliminate the risk of psychological hazards. One of the two egregious forms of psychological hazards are bullying and sexual harassment. So as an employer, I'll come back to Victoria in a second, you must be satisfied that you have methods in place that people have knowledge of what is wrong and they will not do it. So it's not enough of saying we'll give you each 2 drink tickets. It's a matter of actually making sure people clearly understand what they're not to do, to have them supervise their work function. Remember, when you're at a work function, your supervisors are still supervisors. I want to be very clear about that. They may not be paid for being supervisors, but because safety law is attributional, that is, the action of your supervisor's failure to intervene when they see something is a liability of the business per se. The business will be liable. Now, there is also a change in the positive duties around sexual harassment and providing a non-hostile workplace that exists throughout Australia under our anti-discrimination legislation. That's again a positive duty to make sure that when Kim comes to a Christmas function, she is completely safe. Bit different from last year. You see what I mean? How different it is.
Yeah.
So what does that look like? And I thought what might be fun is to talk about Keenan and Leighton, which is an old case now. I think it's about a 2013 or 2015 case. I can't remember. But it's where a guy turned up. He worked for Leighton's. He came to the Christmas party. He behaved badly throughout the Christmas party. He was blind drunk, saying shocking things he shouldn't have said. After the party was all over, he then met up at a bar with some people afterwards. He actually tried to crack onto the HR person, said some shocking things during that process, touched a few people. And so there became this argument. Can you hear the beneficial piece of the legislation? So he was given a slap across the wrist, but Leighton were told off for the way and they managed alcohol and condoned behaviour at the Christmas party. So he didn't get into trouble about that, not bad trouble. Certainly the summary termination didn't stick for that. And the after party was seen to be out of hours conduct under Rose and Telstra. And perversely they said, and it's not good law, by the way, this case is not good law, but it said, well, no, it is out of hours conduct. It didn't go to the heart of his contract. It didn't interfere with what his future, the 3 tests under Rose and Telstra. Therefore, he can't be punished for that either. Now, I don't think that's right. I think that the fact that he did touch and do things to a person who was a co-worker makes it impossible for him safely to return work and be responsible to them. And on any basis, in my view, and there's a case that comes out of Adelaide around about a sexual assault that occurred afterwards, makes it very, very, very clear that that is out of hours conduct that does fall within Rose and Telstra. But I'm just telling you what this old case says because it shows the level of complexity that sits in these issues, and it speaks to this issue of, well, I'm going to have a Christmas function. I went to one last night. What are the rules around the Christmas function? Okay, well, the rules are really clear. People know before they attend that function. It's not enough just to send an email around. They know absolutely through their team leaders what will and will not be accepted. The people who are present as leaders know what their obligation is. There is proper observation around alcohol consumption and around conduct, and the slightest move is off you go home. And there is a clear understanding that after that function closes, there is no more function. There is no after party. And if you go to an after party, be it on your own, but if a senior leader goes to an after party, the senior leader has to understand it will become a work function and they have a responsibility and a liability for the business. Because I think you and I see too often the senior leader putting over the company credit card 3 hours later at a bar they should never be at, and something occurs. So it's not hard to do this right, but I guess I just wanted to highlight the law's changed. And so the expectation of, have you done a risk assessment? And the risk assessment might be, Kim might say, yeah, Andrew's a dangerous guy around alcohol. We need to talk to him beforehand. And I mean that. That might be the risk assessment. The risk assessment might be you've got 2 or 3 people who've demonstrated in the past poor behaviour in the consumption of alcohol. You might ban alcohol. That could be it. You may say to people, you can't come in the room if you've been drinking. Whatever your control is your control. But I can think in every law firm that I've ever been in, there'd be 2 or 3 people as part of any risk assessment I'd go and have a chat to and say, I'll be watching you. And if your behaviour moves, you're out. And if you do that, it's breach of a lawful and reasonable direction. And you're not only out the door there, you're out the door of the firm. So I thought I'd raise it up. It's just not hard to do, but you've got to understand these positive duties do require you to assess the level of risk beforehand, look at the history of what has occurred beforehand and introduce controls not to manage it, but to prevent the risk from arising.
Yeah.
So that's my pitch. You can tell I've done it so many years in a row, can't you? What about you, Kim? What do you think? We're not seeing less, are we? That's the problem.
No, we're not. And I mean, that BHP Rio Tinto case just demonstrates how appallingly people behave, even on a day-to-day basis.
Yeah.
So it all comes down to the culture and just
the willingness to stand up. The willingness to stand up and say no.
Mm.
Do you know that the data is just shocking? So the data is that all women by the age of 40 have suffered some form of sexual harassment. I think it's over 25% of women have experienced in their last job sexual harassment. All people have experienced bullying in their life. 18% of people experience bullying in a year in their workplace. That's nearly 1/5 of people in a year experience bullying in their workplace. Now, they're not figures which you can challenge, they're just the truth.
Yeah.
And it says that as a cohort, humans are pretty bloody ordinary. And so culture does have to be defended. It has to be fought for. You know, you must, I think we said in our sexual harassment training, you know, you are my Praetorians. It's your eyes out there that stop things happening. Because by the time I see it, someone's been harmed. That has to be the workplace that we live within. Why don't we check it out with that problem? Why don't we go on to our case study? It's got a few pages. I got a bit carried away.
Okay. Okay, Dave was a crew manager at the Abbotsford site, one of 12 sites being developed by Garson and Gates, the builder in the Greater Melbourne area. Dave had completed his online bullying and sexual harassment training in late December. Several documents, including the sexual harassment, discrimination and bullying policy, appeared on his computer throughout the month. These had to be acknowledged before he could use it. Garson and Gates held their usual Christmas party at the casino on the second Saturday of December, with over 400 construction workers and their partners in attendance. Dave had frequent issues with the head of safety, Natalie Strong. He was often rude, belittling her in front of co-workers, but she was tough. Although polite and respectful, she gave as good as she got. Natalie was a university-educated woman who dressed in tailored suits, except when on site. To Dave's ear, she sounded rather pretentious, like a precious private schoolgirl. Dave was a chippy, smart, hard-working, but recently separated and embroiled in a bitter divorce and custody dispute over his children. Always a bit of a drinker, he arrived at the casino pretty charged. Natalie enforced a safe drinking policy at the casino. Each person was only given 3 tickets, allowing 1 alcoholic drink per ticket. But that didn't stop Dave. He collected spare tickets from many of his staff who were from overseas and had cultural reasons not to drink. As a result, he got hammered.
You like that? I got back to the vernacular.
I love it. When Natalie saw him intoxicated, she approached him and suggested he leave, offering to arrange transport. As she put her hand on his shoulder to guide him out, he responded by placing his hand on her buttocks, squeezing it, laughing, along with several other men before leaving the room. He then went down to the gaming area and returned 2 hours later after the event closed at 12:30 a.m. Only Natalie, his head of operations, and 1 other crew manager remained. He was obviously drunk, made rude and suggestive comments to Natalie, and then left, telling an older man at the door to get out of his effing way, who turned out to be the CEO. On Monday morning, he was directed to attend the head office on Collins Street, where his employment was summarily terminated. Okay, so could Natalie have a successful sexual harassment claim?
Yes,
no doubt.
Absolutely no doubt. So remember when I was pointing over there to discrimination law, beneficial legislation unquestionably shares a claim. Could she have a bullying claim, historical bullying claim? Yes, she could.
Yep.
Not so much. I mean, that might play out in a common law claim, but as a bullying claim stop order, it'd be resolved. He's been sacked. It's gone. Yep. So the bullying claim is really a common law claim. A workers' comp claim, Kim?
Yeah, she would.
Yeah, absolutely.
It would be, even though it's a work event outside of the hours, it would be definitely in the course of employment.
Now here's the one I chucked in. Is there a general protections claim? Yes, because he's got a discrimination claim, which is a protected attribute, and his behaviour towards her breached that protected attribute, and the organisation should have prevented it. So she does have a general protections, and that's not nice for them because the fact that it has occurred is an admitted fact because they've sacked him, and therefore the reverse onus is on them to show that in respect of her, and the general protection claim, of course, is they do something bad to her as a result of it. So there has to be, they say to her, look, I think you need to stand down for a while or do something. It has to be a bad part that comes to her. There's no bad part, no claim.
Yeah.
But commonly it does happen after a sexual harassment claim, and HR people particularly are then treated badly as a result of raising an issue that relate to them.
Yeah.
So it might be, that's enough of that, Natalie. You dealt with it. He's sacked. Get on with it.
Yeah.
Remember, general protections claims can arise after termination or during the course of work. So I just put it in there to show you it's a live issue, and when someone raises a complaint, and I don't know how I knew about BHP and Rio beforehand, but a whole part of that case is about people being fearful of advising in respect of allegations because of the consequences for the person who did it. It's very similar in HR, who are often caught between quite aggressive management who do the right thing and fire the person, but then really take it out on you as the person who created the risk afterwards. So it's there. It's only a small issue. I just wanted to tag it. Okay. Breach of safety law. Totally.
Yeah.
Okay. What about Rose and Telstra? Was this out of hours conduct? So for Rose and Telstra, you've got to ask these questions. Does it go to the heart of the contract the person is with? So by doing what they did they affect the contract? There's an argument they did. Did it interfere with the capacity to work safely with another person? Absolutely, and that's the trigger.
Yeah.
Does it go to the reputation of the organisation? Yes, it does. So on 2 out of 3 for Rose and Telstra, it only needs 1. It is definitely part of work.
Yeah.
And I guess that's why I wanted to push this, why I put Keenan up early, because I think it was wrongly decided, Keenan. But there's a whole lot of cases like Keenan that decide absolutely behaviour which follows a Christmas party with senior people at that Christmas party where behaviour is permitted.
Yeah.
Rose and Telstra. Okay. Let's have a look at the next one. Did Dave have a viable unfair dismissal, assuming he was given procedural fairness? What do you reckon?
I'm trying to remember the facts.
Oh, come on, you just read it. So he did some bad stuff during the party, but he was allowed to drink in the manner in which he was, and nobody stopped him until such time as he was directed out, and then he sexually assaulted Natalie Strong. I think he's in real trouble with the sexual assault. And the Fair Work Commission at the moment is basically got a hard line, particularly under Hatcher as president, which is if you sexually assault someone, it doesn't matter about procedural fairness. You're out the door. So I think he's in heaps of trouble.
Yeah.
What occurred afterwards, Rose and Telstra argument, I think is enough to immediately terminate without any doubt at all. So he's gone.
Good.
Now, what are the psychological hazards that occurred? So there's obviously the sexual harassment that's occurred, but there is also this differential treatment that exists across an organisation. So there is the operational justice problems. Yeah, it's really just the big one, sexual harassment, but there is a whole lot of condonation which brings all the others back into play. Yeah. And I think when you've got somebody who is a national safety manager like Natalie, trying to drive safety, and a person like this historically treats it badly and other people allow it, sexually harasses and other people laugh, you realise there is a much bigger set of psychological hazards that exist than sexual harassment. So I want to put that in because I want to say to you, we have to do a new analysis around behaviour, which is to look through the lens of psychological hazards now. Before we just said they behave badly, but what is it about their behaviour that is bad? More importantly, how does it harm people? And there's harm going on all the time in this story, not just to Natalie, but to a whole lot of people because of the culture that existed. And as I said, this was written before we got the Rio and BHP class action notice. There's a story that speaks to the very issue we're talking about. I don't think we've got any more questions, have we?
That's it. We're done.
We're done. So can you give us the thumbs up because we've worked very hard with very little notice and we're very tired and we just want Christmas to come and Santa, please come early. Thanks very much. We're back on in February, okay? So we're taking a break for a month now. Thanks, Kim. Lovely to catch up for this last time. See you soon.
Bye, everyone.
Bye-bye.
Merry Christmas.